Good morning. My name is Jeff Coyner. I'm an attorney here at the Green Law Group. This morning we're going to do a little talk about coverage issues in construction matters. So we can go to the next slide. We're going to go through a PowerPoint here. The PowerPoint's going to be sent to everybody tomorrow, so if you want to get a copy, it'll show up then. And anybody who wants to watch this at a later time, we're recording this, so I guess it will be also available for people to take a look at. So this page is just a list of our sponsors. Just want to give everybody a quick notice that I'm not trying to give legal advice during this. I need to know the facts of your case. I would need to see your policy. So it's really impossible for me to give legal advice in an environment like this, but this is just general information that hopefully will help you guys dealing with construction insurance in general. This page just briefly talks about the Green Law Group, our history. We generally specialize in construction, all aspects, licensing, notices. We even have a tax attorney. We deal with corporation setup, pretty much anything that your business needs regarding construction law. This is a list of our attorneys. I've been with Green Law Group about 4 years now. So let's move on, and I'm going to talk just a second about my background. I actually worked for Anderson Kill Olick, which is New York based, firm that deals in insurance issues before I came to work for the Green Law Group. I have extensive experience in dealing with all kinds of insurance policies, and I've fought with pretty much every insurance carrier on a very large number of issues over the years. I will say that construction law is probably one of the most complex areas of insurance I've ever dealt with. I don't think that too many attorneys even have a real good grasp of sort of detailed understanding of construction insurance. I'm not trying to teach everybody everything there is to know today, but hopefully you will come away with some things that you can consider when you're running your business, and things that will help you along the way. The two main issues that I'm going to talk about is what comes up the most day to day in my practice. The first being that when contractors purchase insurance, and I'm talking about general liability insurance. I won't go into employment, EPLI, or E&O today, but so for general liability insurance, so a lot of contractors buy policies that are not really sufficient for their business needs. And then when a dispute does come up, I come across a lot of problems with the tendering of complaints and claims to insurance companies, and I found that the contractors, brokers, and even a lot of attorneys don't understand what really needs to happen when you're tendering a defense if you get sued to an insurance company. So briefly, let's talk about what a commercial general liability covers, what it is. And in the start of almost every policy, it will say that the insurance company will pay all bodily injury and property damage that the insured becomes legally obligated to pay because of an occurrence. That's generally the core of what a general liability policy covers. Bodily injury is pretty self-explanatory. Someone gets hurt, caused by an occurrence. Property damage caused by an occurrence also seems pretty self-explanatory. An occurrence is almost always defined as an accident. It has to be an accident. Insurance companies don't cover intentional acts. I can't buy punch my neighbor insurance. I can't buy steal from the bank insurance. It only covers the accidents. There's public policy reasons why you can't buy insurance that covers intentional conduct, and there's a statute that mandates that insurance companies can't sell that. So, but that's still a very broad definition of what it covers: accidents that cause bodily injury or property damage. Then come along the exclusions, and the way I explain this to people is you start out with a block of cheese, right, for what your insurance covers. Then the exclusions come along and they take out various portions of what is and is not covered. And so they start poking holes in that block of cheese and eventually end up with Swiss cheese. You got a block with tons of holes in it. And that just means that, commercial general liability policies are commonly a couple hundred pages long. And so that statement I said at the beginning about what was covered, a vast majority of the rest of the policy is cutting holes in what's covered. It's taking things out, whether it's mold or pollution or a vast number of things. So things that take away coverage are generally called exclusions, and they matter because you have to be very mindful when you're running your business about what is not covered in your policy. So the exclusion that's at issue in construction cases for construction companies is called the your work exclusion. And essentially, it says that the construction insurance, the CG or the general liability policy, does not cover damage to your work. And that sounds a bit confusing because I just said it covers property damage, but it doesn't cover property damage to your work. And I think the best way to explain that difference is to give you an example of how the your work exclusion works. So I'll give you a little bit of an example here. So case study: roofer. The roofer's puts on a roof. At the end of the job, one of the roofer's workers accidentally punches a hole in the roof. Later on, the roof leaks and causes water damage to drywall in the house. Causes a big puddle and stain on the ceiling drywall. The owner sues the roofer. So the question is, what will your CG or your general liability policy cover? Will it cover to repair the hole in the roof? No. If you're the roofer, that is your work. And the easiest explanation is if the contractor was paid to do it, if it was done wrong, it's on the contractor's dime to correct the problem in that work. So patching the hole in the roof, not covered. But will the insurance cover repairing the wet drywall, the stained ceiling? Yes, it will, because the roofer didn't install the drywall. That wasn't part of his work. So as an insurance attorney dealing in construction, I'm always looking for resultant damage to work that was not done by the contractor. And it gets a little more complicated if you're a general contractor and you have subs. Damage between the work of your subs may be resultant damage, even though they're your contractor. But an issue comes up of completed operations, which is really something that you need to consult an attorney with. So if you're a general contractor, you have a new ground up construction, everything is your work, right? Everything from the foundation to the paint. But there are ways to get coverage for in that situation, but that really is something you should talk to an attorney about when you come across those claims. So that's sort of going back to my original statement about the two issues I deal with the most. The first one is contractors buying the wrong insurance. And this almost always is the result of a breakdown between the contractor and the insurance agent or broker when they're applying to get insurance. The forms that contractors fill out, sometimes they're only a page or two long. A lot of them have yes or no questions asking about what the contractor does, but they can be vaguely worded. And when a contractor fills those out, they don't understand that the reason the insurance company wants answers to those questions is because they're looking at what exclusions can go into the policy. So when the contractor fills those out, they don't really understand the impact that can occur. So examples I have of this, where a contractor who does a type of work ends up with exclusions that really don't make any sense for their business, and when they've come to me after the fact, trying to get insurance coverage, I have a very difficult time getting it. So let's go through some of the examples. I had an earth drilling contractor who sold a policy with an earth movement exclusion. As an earth drilling contractor, somebody who's putting in foundation pillars, the damage that's caused is almost always related to earth movement. So when he came in, it was pretty much impossible to get coverage because it was excluded. And I've had contractors who have policies that exclude new construction, even though the contractors occasionally take ground up construction projects. So if a problem arises on one of those projects and there's a new construction exclusion, there may be zero coverage. And again, when you fill out the questionnaire by the agent or the broker, it may ask if you are going to do any new construction in the next policy year. If you put no, you're not, you better contact your agent or broker if you do take on, or an attorney if you do take on a new construction project, because your policy very well may exclude new construction projects. So when you fill out those insurance applications, it's looking forward a year, and anything that you say you don't do, if you change in any way, you need to let your agent or broker know, because you might have to buy a new policy or amend the policy. And it's my experience that brokers and agents really don't explain that very well to contractors. Other examples, I've had framing contractors with exclusions for residential remodel framing. It's the same thing. The contractor most likely put on their application that they didn't do residential remodels, so that ends up as an exclusion. So often I get ask why, if they have these exclusions, are the insurance companies selling these policies with a lot of exclusions? It's simply to keep the cost down of the policies. General liability policies are going, I think everybody understands, generally they're moving up in price. So there's a lot of pressure to try to reduce the price of a policy. The insurance carriers do that by taking out things that they cover within the policy because it reduces their risk. So that's why there's this back and forth, and you need to be very accurate in what you tell your agent or broker you do, so that they're not backing out things that you need or end up needing in your work. One specific issue that comes up are scope of work exclusions, and those exclusions say that the insurance company is only going to list or only going to cover damages that arise out of the scope of work as it is defined in your insurance application. Now, when a contractor fills this out, they see a box in a policy application and to say, what do you do? And my example here is I had one case where the issue came up where there was a foundation contractor who wrote foundation, no foundation repair as what he did. And then I got in a big fight about whether a remodel of a house that included upgrading the foundation was a repair or was it new foundation. And because of this very thin definition the contractor wrote down, it caused a lot of problems. So again, the most important thing is to have your agent or broker fully understand what it is you do. Now, agents and brokers can be held liable in court if they sell you the wrong kind of insurance policy and you relied on them to get it. That's on the one hand. On the other hand, there's an assumption that you read and understood the policy that they bought. I think anybody who's tried to read more than 2 pages deep into a insurance policy, most everybody's eyes glaze over. They're incredibly hard to move through. So a vast majority of the time, the contractors don't really understand what they bought. So the best thing you can do to protect yourself is to make sure that you have a clear record of exactly what you told your insurance agent or broker, and this needs to be in writing. I've sued agents and brokers. Not surprisingly, if you rely on what was verbally said, the accounts of what was said differ huge when you get into these kind of fights. So it needs to be in writing. So my recommendation is when you fill out any insurance application, you just include a page that you staple onto the back of it that explains in detail what it is that you do. And understand that if you buy an insurance policy and you're going to do something that's not stated in what you tell them, that you either need to talk to an attorney or you need to talk to your broker or agent about what you're doing to see if it is in fact covered, because I don't think anybody would expect a contractor to be able to read the policy and make that determination. So, so that's covered. We're just finished the first item I wanted to cover, which was making sure you buy the right insurance and how you can make sure you have the right insurance if a claim comes up. The next issue relates to tendering a defense. And tendering a defense means that you tell your insurance carrier that someone is making a claim or filing a lawsuit or maybe demanding arbitration against you for something relating to an accident or that occurred, personal injury, property damage. You're getting sued. Long story short, or you're about to get sued. So the tender is telling the insurance company about whatever's come up. Now, there's two things that matter when you are talking about insurance coverage regarding third-party claims. That's when someone else is making a claim against you, as opposed to first-party claim, where you're, if you have vandals damage some of your equipment, you don't know who it is, you make a first-party claim to your insurance to help pay for the damage. Roof leak in your house, you don't know, you don't have a claim against the roofer, it's an old roof. That's something the first-party claim, you asked your insurance company directly to pay. Third-party claims are where someone is suing you or making a claim against you, and you're asking your insurance company to cover it. Two aspects of this. The first is the duty to defend, which means whether or not your insurance has to pay for an attorney to defend you against that other person's claim. And then there's the duty to indemnify, which means if there's actually damage proven, how much will the insurance company pay of that damage? So they're two very different things, and they have two very different standards that they go by. Duty to defend is very broad. It means that if there's even a possibility that what they're claiming is going to be covered, that the insurance company would have to pay money out for the actual damage, then the insurance company has to appoint you an attorney and cover that. Now, this is important because this is probably what I come across the most. In a duty to defend, it matters both what actually happened and what the other side is claiming, even if it's not true. So if I have a stucco contractor and he comes in and he says to me that the owner is upset because the cement patio was damaged, and the owner is claiming that it was damaged during the stucco contractor's work. So resultant damage sounds good, but the stucco contractor tells me that they didn't cause the damage. They know it was some other contractor, or the owner did it, or whatever, and he's got absolute proof that he didn't cause that damage. Okay, under duty to defend, even if the contractor didn't actually cause the damage, the insurance company has to defend him against claims that he did. So it matters just as much if the contractor knows they did have an accident cause damage as if the owner's claiming something that never even happened, as far as a duty to defend goes. And this can be evidence from any source. So if I get a complaint that doesn't say it, I can pull out an email where the owner was complaining about something was damaged. That will often be enough to trigger a duty to defend, even if it's not expressly stated in the complaint. So this gets a little bit complex, but this is why it's important to talk to an attorney when you get sued in a construction case. I talked about, you've got a 200-page policy at the, a lawsuit is filed, even when an insurance carrier picks up to defend a case, you will always, in a construction case, get a reservation of rights letter, and this is a recent one I've got. It's about 30 pages long, and it consists of 30 pages of all the reasons that the insurance carrier is not going to pay for damages based on all the exclusions in the policy. So you get sued, even if you do get a defense. Back to my prior statement, you have duty to defend, duty to indemnify. Even though they say, well, some of this may be covered, they're going to send you a reservation of rights explaining why almost all of it isn't. And so when it comes time to pay money to try to get a case settled, the insurance carrier is going to look at what they think is covered, and they're going to put up money for that, and they may look to you to put up money to cover other things. So this is why it's so important to have an attorney at least somewhat involved, because you need to be able to make arguments that things are covered, and you need to be able to get through an entire policy and the reservation of rights and understand what those mean. So let's go back to my roofer case study. So it says, will the insurance carrier pay for the defense of the leaky roof if the complaint doesn't say anything was damaged? And, you know, in a construction case, I might get a complaint or a demand letter, and it may just say that the roofer put on the roof below the standard of care, and the owner was damaged in the amount of, let's say, $25,000, and it won't say what was damaged. It won't say if that's just the cost to fix the roof. It won't say if the owner wants a new roof, both of those things not covered, or if water leaked into the house and maybe destroyed a bunch of things that need to get replaced, which is covered. My experience with insurance companies is if the complaint or the demand from the other side doesn't specifically indicate covered damage, that they won't pick up. They will send you a denial, say they're still investigating, and will not defend. And that can be, well, in this case, easily corrected if the roofer had any emails where the owner complained about water getting, you know, damaging drywall or getting in the house. If the roofer had pictures of water damage in the house, even if the roofer says that the owner came and orally complained that there was water damage in the house, if I send that along to the insurance carrier, I very well may get a defense right away in the case, even after an initial denial. Or sometimes I can look at a complaint, see that there's going to be a problem, and we'll send that when I first tender it. So that is important. Again, I think most insurance agents, brokers, and even a lot of attorneys, even construction attorneys, don't understand the coverage aspects that come to play when you're tendering a complaint, or the fact that if you get a denial to a claim, that I think more than 90% of the time I can get coverage if I just investigate and look for items that are going to be covered. Just as an FYI, almost all insurance policies exclude attorney's fees paid by the other party. So if you go to trial and you lose, and there's an attorney's fees provision, and the other side gets their attorney's fees against you, that will not be covered almost any general liability policy that is sold today. They used to cover it, they don't anymore. It's important because even a simple, smaller case will cost a couple $100,000 in attorney's fees. And so it is something that you can do things as far as making offers early to impact the other side's ability to get fees, but it's something that needs to remain in the back of your mind, even if the insurance company picks up and defends. Again, there are big things that will not be covered. So we need to keep that in mind. So now let's go to why tendering matters. Why does it matter to give your insurance carrier this information? It puts the insurance carrier on notice. Once they have notice, that's when they have an obligation to make a decision if they're going to defend you or not. And if they do defend you, and it's often that carriers take 2 to 3 months to make a determination whether they are going to defend. But if our office or another attorney that the contractor hires in the meantime, after they've tendered, to when an insurance carrier decides to pick up, all of that will get reimbursed to the contractor. So very common, I'll get a complaint, I'll tender it, I'll have a little back and forth with the insurance carrier. 3 months later, the carrier will pick up the defense. In the meantime, the contractor spent $8,000 to upwards of $20,000 defending the case with our office. All of that will get reimbursed to the contractor. This is why it's so important to put your carrier on notice when claims come up, because your ability to recover during that time, any money you put out, greatly goes up. The tendering matters because, to be frank, cases are often won or lost at the point of tender, because if you don't get a defense, generally speaking, it means that the contractor is going to have to come up with money and pay to get out. And it's just an economic decision, because the plaintiffs, usually the owners or people suing you, know that the contractor doesn't have a ton of money. But going through trial is going to cost a contractor more than $70,000 in the smallest cases, and can go up to, more than $500,000. And so if I'm an attorney on one of these cases, I'm gonna almost always recommend that you tell me whatever it is the most that you can pay, and we'll take that and try to, negotiate paying less, but you're gonna have to pay 20 grand to get out of the case. The plaintiff may not keep you in because you don't have a deep pocket. If you don't have insurance, they're not going to get paid. But you'll spend so much more defending than you will just paying to get out. That's the situation you're going to be in. So anytime you get a lawsuit, it needs to get tendered, and you need to see if you can get a defense, pretty much, period. Now, which policies you tender to, it gets complex. If you're an additional insured, if you have an additional insured endorsement, you're a general contractor and you get that from your subs, and as a insurance construction attorney, I always recommend you do that if it's possible, because then if you're the general contractor, you're also covered, you have your own policy, you're also covered under your subcontractors' policies. And there's no question about that. And so This also gets around the issue of the your work exclusion, because you're covered under that subcontractor's policy. If he damages another person's work, you're going to have coverage. Whereas in if you're the GC, your general liability, the insurance company can argue that all of the subs that work under you fall under your work. So as a general contractor, if you can get additional insured endorsements, that is always the way to go. The other ways you can get them, really you need to talk to an attorney, because insurance certificates don't really do anything for you other than tell you that the subcontractor has insurance if you obtain those. But it doesn't tell you what the exclusions are, which may get rid of the insurance for the sub. And just having an insurance certificate doesn't mean that the general contractor is going to be covered under the sub's policy. That will depend on the specific language in your subcontract. Again, I would recommend an attorney look at the language in your subcontract. It will depend on your policy and the subcontractor's policy, but that language may also trigger the subcontractor's insurance to have a duty to defend the general contractor. And this, when I say general and sub, that also includes a sub who hires subs. You know, you've got a sub, you're in the same situation. If you have an additional insured endorsement, you can get coverage under your sub. So all that matters. So how to tender? Really, all a tender means is that you tell the insurance company that you're getting sued or somebody's making a claim against you. It doesn't have to be in depth at all, but if an insurance company doesn't get more information, then they will never pick up and agree to defend you because of all the exclusions. They'll just assume that as a contractor, the insurance company by default will always assume that you are getting sued because you did bad work and only your work was damaged. That by default. So until you tender and give them proof of that coverage is in play, they will deny. You know, we've all dealt with insurance companies. Insurance companies make money by accepting premium. They lose money by paying out defense and indemnity costs. So there's always a conflict there. They make money by denying claims. That's just a fact. So so when you tender, I think it's always worth having an attorney review a copy of the complaint and your insurance policy. Now, even in our office, we do initial consultations are half hour or so, are always free, and someone like me can take a quick look at your complaint and look at your policy and give you a general idea of what you're looking at. And I always recommend that because it's too complex, frankly, for anybody but someone who deals in these areas to look at a 200-page policy and a 30-page complaint and figure out whether or not there's going to be coverage or not. So a couple of other issues that come up. And another reason why I think it's very important for an insurance attorney to review claims against you is because of all the exclusions, if an insurance company may admit that they have to defend you, but you may have a right to choose your own attorney in the defense. Usually the insurance company will appoint what's called panel counsel to defend you. And I worked for about 4 years as panel counsel for State Farm, and most of the attorneys are pretty good. But those attorneys are paid for by the insurance company, and they are not allowed to consider any of the insurance issues that I've just spoke about when they defend you. They have to pretend that no insurance issues exist. Courts have said if there's a big enough dispute between the insurance company and a insured about what's covered and what's not, that at times the insurance company may have to pay for the contractor's personal attorney to defend the case. And in that case, obviously, that attorney can consider all the coverage issues and can build the defense around how to get as much coverage as possible if somebody loses, and or how to get the insurance company to pay as much as possible to get you out of the case. Back to how to tender, the language and what is given to the insurance company matters a ton. It needs to be well thought out, particularly if it's questionable about whether or not you're going to get a defense just based on the complaint or the maybe a mediation demand letter you got from an owner or another person in the third-party claim. So again, you should have somebody who knows what they're doing looking at those. The other thing that comes up, and I've had just this recent, attorneys will draft complaints to try to avoid triggering insurance coverage for the reason I said before. They know if you get coverage, there's going to be a fight. If you don't get coverage, they know the likelihood of a fight goes way down. Even when they try to avoid coverage, though, I can get information from other places and show property damage that would be covered, and an insurance company will have to defend. So I know I went through all that very quickly. I guess we had about 20 minutes where people can type questions they have, and I'll do my best to answer anything that you have. If we don't get through it today, if you have a question, you can always look me up and email me at my email's at the bottom of the page here. I generally will answer quick questions, free of charge. Not a problem. Just give me a couple days to get back to you. And so I guess we can open it up. I guess there's a text box, and anyone who has any questions is free to ask. Well, so far, we've got none. We'll wait another couple minutes and see if anybody's got anything. If not, again, everyone is welcome to call or email me if you have anything that comes up, either now or if you are watching this as a recorded version at a later date. Okay, I think we're done for today then. So thanks for your time.